Welcome to Leaving a Legacy, Navigating Estate Planning with Rose Harper Law.
Hello and welcome back to Leaving a Legacy, Navigating Estate Planning with Rose Harper Law. Rose is the founding attorney of Rose Harper Law, where she helps families protect what matters most through estate planning. I'm Chelsea Reynolds, and today we're going to be talking about guardianship and conservatorship and what happens when a loved one can't make decisions for themselves. Welcome back, Rose.
Thank you so much for having me. These are really important topics, so I'm glad to be discussing them with you today.
Is it okay if we start at the basics and just you can explain the difference between guardianship and conservatorship?
No, absolutely. A lot of times people throw around legal terms and they actually do have different meanings, but people will interchange them. So it is important to really understand, what do those terms actually mean? So they are, different roles and they have different capabilities. And if someone is appointed as a guardian, that means that they have the ability to manage the personal affairs of someone who's deemed incapacitated. And that can include decisions from their living arrangements, medical care, day to day well being. So basically, a guardian is someone who can make all of your decisions except for, when someone can't make the decisions themselves, right? And then a conservator is, someone who is appointed to specifically manage the financial affairs and the property of that individual who cannot make decisions for themselves, who is deemed incapacitated. So that would include like paying bills, managing investments, handling their assets. Some states will use those terms interchangeably, conservator or guardian. Some will say guardianship of the estate to cover financial matters, but the core principles are the same. You want someone who is going to essentially take on the responsibilities of making those day-to-day decisions for someone who is unable to make the decisions for themselves.
And what circumstances would a court make and appoint a guardian or a conservator for someone?
So a court would intervene and appoint a guardian or a conservator for someone if they are legally deemed to be incapacitated. And that really means that they're unable to communicate sound decisions about their own health, safety, or finances. And someone could be incapacitated for a variety of reasons. And that includes, advanced age, cognitive decline, something like dementia or Alzheimer's. Maybe they have a mental illness or a developmental disability. You could be deemed legally incapacitated due to, physical illness or chronic substance abuse, even. And then also someone who's a minor who's receiving a large inheritance or settlement could be deemed incapacitated. So the courts then would say that, for example, in a personal injury settlement, if someone's receiving that as a minor, it has to go into a separate trust bank account for them until they become the age of 18 and can receive it. And then the same thing for an inheritance. I don't think people realize that, when developing your estate plan, you want to take into account the age of your children and how old you want them to be when they receive their inheritance. Because with no plan in place, they can receive it at 18, but before 18, that means a court's going to put it into a trust and choose for you who should manage the money for them if you have no plan in place. If you document who you want to be your kid's guardian, then you can decide who's going to manage it for them.
That's super important. So you've mentioned some scenarios that might happen. What are some signs that a family should watch out for to say, maybe suggest that a loved one can no longer manage their own affairs?
Yeah, definitely. There are certainly red flags to look out for. And if this is occurring in any of your loved ones, life, it's something to really think about, at least starting the conversation, reaching out to an attorney who might be able to help guide you through this process. But some financial red flags that might be occurring is, unpaid bills piling up, large or unusual cash withdrawals, falling victim to scams, general confusion about how much money they have, where it's located. Personal care red flags would be, a significant decline in personal hygiene, self care, dressing inappropriately for the weather. You can even consider like their home living conditions. Has their home become unsanitary, cluttered, unsafe? Medical red flags would be like missing a lot of doctor's appointments or not taking their prescribed medication correctly, being unable to follow medical advice. Behavioral changes would be a lot of confusion, disorientation, significant changes in mood and personality, memory issues. So, if you see any of these signs, definitely speak with a doctor and also speak with a lawyer to discuss, what this might mean for your family. Because the entire point of putting a guardian or a conservator in place for your loved one who might be legally incapacitated, if you're noticing these red flags, is to prevent them from being victim to, harm, abuse, or financial exploitation. We want to put someone in place to protect them.
Who would be eligible to become a guardian or conservator? And what does the court take into consideration when they're making that decision?
So, generally, any adult can petition the court to become a guardian or conservator. The court will, however, follow, a strict process to determine the most suitable candidate. So, they're going to prioritize someone who is qualified, capable of performing the duties necessary. They're willing to serve. So you won't be forced to take on that role of guard because it's a big role, it's a lot of
Yeah.
responsibility. So, qualified and capable, willing to serve, and um, someone who would have the best interest of the person that needs protecting. And the court, of course, will consider the person's own preferences if they're able to express that. And also, the court's going to conduct a background check, including criminal and financial history. So, family members are typically given preference, but the court has the ultimate decision to decide what is in the best interest of the incapacitated person. So it's not simply just like who's related to you. The judge could make a court appointed, guardian for you.
That was gonna be
If you
my
don't,
follow yeah.
yeah, yeah. So like that's why also like as you're starting to see red flags, if it's not too far gone and your loved one is able to have capacity enough to get things into place,
Mhm.
to choose who they want to be their guardian, that will really help the court make that decision. Otherwise, a judge can only do the best they can, but they're a stranger to you and your family, and they're going to have to try to navigate this with whatever evidence they're presented.
So if somebody doesn't have a lot of family, um, and you're a good friend and you start seeing red flags, you could still take these actions and go to a doctor or go to a lawyer on their behalf to take care of them.
Absolutely. Yeah, and that happens, people have smaller families, sometimes people don't have children or their parents have already passed, and so really if you have a good friend that's looking out for you, that's amazing. Otherwise, usually it's like a doctor will pick up on it, or if you're already in, like a nursing home or something, they'll usually pick up on, "Oh,
Mhm.
we think maybe we need to reach out to a lawyer or a doctor to get someone in place for this person because they're not able to, communicate with us and, properly take care of themselves."
And once somebody's appointed as a guardian or a conservator, what kind of responsibilities does that come with?
So definitely, there are a lot of responsibilities with this position. They'll be specifically outlined in the court order that appoints you if you become a guardian or a conservator. But essentially, you're bound to make decisions that are in the best interest of the incapacitated person. And that will also include like filing reports with the court on a regular basis, typically, because you want to document the well being of the person that you're a guardian of, including the management of their finances as well. And you'll have to seek court approval typically for any major decisions like selling their property or any like major medical decisions or procedures. So you want to maintain, detailed, meticulous records, and it can be a little bit cumbersome, but you know, essentially the whole goal of having these checks and balances in place is again to protect that incapacitated person. So you'll want to keep track of financial transactions, expenditures, because you're really acting in a fiduciary role. So you have the highest level of care possible in the best interest of the incapacitated person. So it's definitely a major responsibility. It's not to be taken lightly. And the court is going to be overseeing everything on an ongoing basis. It's not like you're just appointed and then, the court is never involved again.
And talking about the person who is incapacitated, how does guardianship affect their rights? What kind of decisions can somebody who's under guardianship no longer make on their own?
Having a guardian appointed to make your decisions is very serious. I mean, you lose significant individual rights when that happens because you're being deemed legally incompetent to make those decisions for yourself. And you now have the court and your guardian or conservator making decisions for you. So the court order will typically be very specific about what rights are being removed from the incapacitated person. So that can vary slightly depending on the situation, depending on what the guardian is being put into place for. Maybe the person's able to do some things, but not others. So that court order will typically be very specific. But in general, people could lose the ability to, make their own decisions with regard to where they're living. So
Mm,
like that often happens, like say for example, you have an elderly person who is legally incapacitated and they're insistent on living on their own, but it's actually dangerous for them to live on their own. So that's why that comes into play. Like, well, their adult children are willing to take them in, maybe they're going to get nurse care, whatever the case may be, but making that decision on where they should live because you want them to be safe and have people around them who are going to look after them. It could include losing the ability to make your own independent decisions about, consenting to or even refusing medical care. So that's a big one. If you lose that ability because you are legally incapacitated, then your guardian or your conservators, depending on the state, how they word it, is going to be making those choices. Um, also entering into legally binding contracts, you could lose the ability to do that, managing or selling your assets, and then sometimes even like ability to, go out and socialize on your own or do things like that if you're really being subject to a lot of scams. Guardianship is very serious. You typically only see it for someone who is, really unable to care for themselves and needs someone to step in all areas of their life. But sometimes you can have a court that appoints like a limited guardianship, which only removes like certain rights, which is what I was talking about. Like that court order can be very specific. So it could be a broad guardianship or it could be more limited. It just depends on the situation and, what help is needed because maybe someone can still make all their own, medical decisions, but maybe they're just like their finances have fallen off and they need help managing that. So it can be, parsed out as to what the guardianship covers.
this seems pretty serious. I'm thinking about Britney Spears right now. We can
I
cut
know.
this out if you want, but if I could plan ahead and be proactive with this, with my estate planning, I would definitely take this episode very seriously.
Yeah.
Um, so, what happens if there are family members who disagree about who should be in charge?
That's actually probably one of the, most common things that occurs, unfortunately, is family disputes. That's one of the most difficult aspects of guardianship cases. These disagreements can, really escalate because everyone's already really emotional, and it often can lead to really contentious and costly legal battles. That's why getting an estate plan done in advance when people still have capacity is really, really important because it can, at least reduce the potential for these types of conflicts. But typically, challenges arise from competing petitions. So if multiple different family members are petitioning the court to become the guardian, there could be like that tug of war. Maybe multiple siblings want to have that responsibility. And then the judge is going to ultimately have to decide who should be the person or appoint someone even outside of the family. And then there could be differences on decision making. So even when someone is appointed, maybe a family member, disagrees whether someone should remain in their home or be put into a nursing facility or how the money is being spent. Basically sometimes like old family dynamics, come into play as well, unresolved issues from childhood, or you have siblings that don't get along and, maybe they could accuse each other of, making poor decisions with the finances. So it can get really combative. But, to alleviate that issue, that's why, having the family on the same page or at least documenting what you want. Like I always tell people, like, you know, you have lived your whole life, building a life that you want, and you deserve the dignity of being cared for in the manner you want, in the end. So if you do become incapacitated, that's why getting your powers of attorney, your medical directives, getting everything into place early while you still have capacity is so important because that gives your family instructions. It gives them a roadmap. It's like, well, this is what my parent wanted. So it can, especially if you have adult kids that don't really get along too well, it
Uh-huh.
can really help them out to avoid these types of conflicts.
How can documents like powers of attorney and healthcare proxies help families avoid needing guardianship proceedings in the future?
Yes, it's so important. Proactive planning, meaning planning while people are still have capacity, is essential. I really feel like every adult, no matter your age, you should have an estate plan in place because you're providing instructions to your family about what you want to happen. And you deserve for that to occur, and plus it helps to avoid conflict for your family. Um, and a comprehensive estate plan is really essential, and that includes a lot of documents that need to work together to really protect you, protect your assets, and make happen what you want to happen. But with regard specifically to guardianship and conservatorship, the documents that you would need to focus on are powers of attorney and healthcare proxies. Um, Specifically, especially as someone's getting older, if you're starting to see red flags, but they still have capacity, it's really worth a conversation to get a durable power of attorney in place. Because if you have your durable powers of attorney, you might not need to go through the guardianship process. If you can designate now, who you want to be able to help you with your financials, your legal decisions, your medical decisions, and what you want those decisions to be. The durable nature of it means that it's in effect now. So if you have an adult child that is going to be able, and can help you, then you can get that durable power of attorney in place. You trust them. You know that they're not going to take all the money for their family and give their siblings nothing, that type of thing. Then you can get those documents in place. And that way it kind of eases the process for your whole family and gives you more flexibility and the ability to make choices. You have more control as you're getting those documents into place versus a judge making the decision for you who doesn't know you or know your
Mhm.
family dynamics. So that's very important. They're really the cornerstone of any comprehensive estate plan. When people are younger and you're getting your estate plan in place, like I'm 39, so I do have my estate plan in place. I don't have a durable power of attorney because I don't anticipate, I'm going to be incapacitated, but I could be, God forbid, but, anything can happen any day, and so mine is a springing. That's the difference. You could have a springing power of attorney that only goes into effect under certain conditions, and it can be revoked automatically on certain conditions, like on divorce. Um, or you can have a durable power of attorney. Estate planning is so, like, I just love it because you really have, like, you can protect yourself so well with these documents, and you have so much control and the ability to make things happen when you want them to happen. And I really love that about it.
There are a lot of things you've talked about today that I wouldn't even know were options, which is probably why people should reach out to you.
Yeah.
So, finally, what advice would you give to families who are worried about an elderly parent or loved one and are considering guardianship as an option?
Definitely seek medical and legal counsel as early as possible. Start talking to the doctor about your loved one's capacity. Get a professional opinion on your loved one's ability to manage their affairs. And at the same time, consult an elder law or guardianship attorney to understand the legal process and what options you have available. And you can also explore, less restrictive alternatives from just jumping to guardianship, like maybe getting the powers of attorney in place, having a trusted family member to handle the bills, and, just more supported decision making, before you go all the way to guardianship. But definitely prioritizing communication, open and honest communication about concerns. It can be really scary for people who are getting older. It's hard to, admit that you're not able to do certain things for yourself anymore, or that you do need help. But I think just by in a loving and honest way, just letting your loved one know that you want what's best for them and you're there to help. And, let's get consultations. Let's just see what the doctors and the attorneys are saying are options. And then you guys can decide, what's the best fit.
Well, this is so much great advice. Thank you so much. And thank you, everyone, for listening to today's episode of Leaving a Legacy Navigating Estate Planning with Rose Harper Law. If you'd like help protecting your family with estate planning or guidance about guardianship in New York or New Jersey, visit roseharperlaw.com. And don't forget to like, review, and subscribe to the show so you don't miss the next episode. Thanks so much.
Thanks.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.